I'm very happy to give the floor to Mr. Peter Haynes.
I mean, I've been a practicing lawyer for 35 years, and I've been involved in high-profile cases both domestically and internationally, and perhaps most notably in the last 19 years, as Kate has said, here in The Hague. And in all of those cases, there has to be a decision. You know, somebody has to win, somebody has to lose, and joy and disappointment result in equal measure. As professionals, we learn to accept what Shakespeare termed the slings and arrows of outrageous fortune, digest our mistakes, learn from them, and move on. The fallout from the Appeals Chamber decision in the Bemba case was, however, something else. The lines of division were immediately apparent within moments of the decision within the precincts of this building. Kate hesitated to highlight some of the personal enmity that we felt that day. And in the ensuing 2 weeks, many commentators have taken to social media, criticizing and bemoaning the decision on one side, welcoming it and lauding it on the other. There are no prizes for guessing which side of the debate I fall on, but I'm not here to defend the judgment. Indeed, in many ways, it was disappointing, a missed opportunity. Those of us who are waiting for the Tadic of the ICC will have to wait probably for a very long time. We are still in the dark about the propriety of ex parte contact with the trial chamber concerning the merits of the case. We're still in the dark about interference with privileged conversations between lawyers and their client, the proper ambit of victim participation at trial, how contextual elements of crimes against humanity are proved, and whether causation is an element of Article 28 liability. However, there are lessons to be learned from the Bemba case, some of which arise directly from the Appeals Chamber's judgment, and some don't. But it would be short-sighted to ignore them. The judgment is part of the ICC's jurisprudence now. In some respects, it may be peculiar to its facts, in others not. But it's there, and we all have to live with it in the future. I have attempted to identify some of the key lessons learned from the Bemba case. I will necessarily, given the constraints of time, run through them in little more than bullet point form. But before I do, I just want to make 3 short points that have arisen from recent debate. Firstly, the criticism of the fact that the Appeals Chamber arrived at its decision by a majority seems to me to be entirely misconceived. Majority decisions lie at the heart of democracy. Governments are elected by majority. Referenda are won and lost by a majority. Laws are passed by a simple majority, and many appellate decisions have been decided by majority, some of them the most significant landmark decisions in legal history. The UK Supreme Court, for example, decided the Brexit legality by majority. Miranda in Arizona was by a majority of 5-4, and as we all know this week, the Supreme Court of the United States upheld the Trump travel ban by exactly the same margin, 5-4. Moreover, I think the issuance of separate opinions by 5 judges indicates an engagement by all of them in the issues before them. Far too many judgments in international criminal law in particular have the hallmark of being written by one legal officer and simply signed up to by 4 judges who didn't want to do their job. Secondly, and this seems to have got lost in the wash, the evidence in the Bemba case was extremely poor, especially on the key issues of command and crimes against humanity. One often forgets Mr. Bemba wasn't originally charged as a commander. The Office of the Prosecutor only resorted to Article 28 when it was suggested by the pre-trial chamber in its rejection of charges under Article 25. In order to make the evidence fit the charges, the OTP jettisoned all evidence of the command chain, relying instead on victims and hangers-on to prove the elements of command. It was, from the outset, a unique and forlorn endeavour. As to the contextual elements of crimes against humanity, the misgivings of the appeals chamber were obvious, especially in the oral arguments, where prosecution advocates were pressed by the bench to agree that nothing plus nothing equals nothing. Thirdly, the Bemba trial judgment was of extremely poor quality. The citations to evidence were substantially erroneous. The trial chamber misappreciated the burden and standard of proof, ignored relevant evidence, mischaracterized evidence, and drew inferences without any proper basis. All three of the majority of the appeals chamber were of that opinion. Indeed, the president, in concurring with Judge Morrison and Van der Weingart, stated that there was so much more wrong with the factual findings than they had identified. Thus, expressions of surprise on blogs and on Twitter at the appeals chamber's decision from those looking in from the outside are water off a duck's back to me. I lived this case for 8 years. I saw the witnesses, I read the evidence, and pored over the trial judgment. It was a rotten case from the outset. Ultimately, thanks to the integrity of the three judges in the majority, it got what rotten cases deserve. Now, leaving that to one side, those were my opening observations, a few of the things we might have learned. Freezing orders. Conceptually, the regime for freezing of an accused assets at the ICC is a departure. We're all familiar with the concept of such orders in relation to assets which are alleged to be the proceeds of crime, perhaps from fraud or drug dealing, where either a conviction has been entered or a trial is imminent. In such cases, the orders remain in force for a few months and are generally justifiable on the basis that the assets are the proceeds of crime. However, the scope of the power is far broader than that at the International Criminal Court. Assets can be frozen to preserve them for reparations or restitution, which might occur sometime in the future. In the Bemba case, freezing orders were made almost simultaneously with his arrest, at a time when it was not known whether the charges would even be confirmed or whether there would be any claimants for reparations, let alone how much. They remained in force for 10 years. Indeed, they remain in force to this day. His assets, of course, had been acquired through inheritance and hard lawful endeavour, not through criminal activity. Far from preserving assets for reparations, the freezing orders simply decimated them. No attempt has been made to manage or protect these assets for anybody's benefit, whether Mr. Bemba or the victims. Mortgages on real estate went unpaid so that it is now liable to forfeiture. Money was left in banks, which went bust. And in the most poignant example of all, actually pictured there, an aeroplane was left to rot on the apron at Lisbon Airport, such that it is now a liability, not an asset. In a civil claim, a freezing order, sometimes called a Morava injunction, would be accompanied by an undertaking by the freezing party to indemnify the frozen party in relation to any consequential losses. It would also ring-fence an amount for his litigation fees. It will remain to be seen whether any liability attaches to the ICC under Article 85 for the losses inflicted on Mr. Bemba. However, this mindless, blind freezing of all an accused's assets from the moment of his arrest, perhaps for a decade or more, simply cannot go on unchecked. The current system benefits nobody and amounts simply to a form of preemptive punishment. A proper analysis of what assets need to be frozen should be made in each case. Frozen assets need to be effectively managed and accounted for. Provision should be made for the accused to pay for his defence. One last comment on this. You may or may not know that, of course, the knock-on effect of all this was that Mr. Bemba was deemed non-indigent for the purposes of legal aid. So despite the fact he could have no access to any of his funds, he was told he had to pay his lawyers. Eventually this Gordian knot was untied by Judge Fulford, who arranged a loan scheme. Partway through the Bemba trial, the funds in a bank account in Cap Verde were liquidated and made available. The registry of the International Court admirably advocated that the money should be set aside for reparations to victims. The Association of State Parties, however, chose to apply it to the court's general budget, thus prioritising the costs and expenses of its staff and operations over the plight of victims. It's something I bear very closely in mind when I listen to people from this institution pleading the cause of victims and in their outrage at Mr. Bemba's acquittal. When push came to shove, paying their salaries was more important than people in the Central African Republic. Which brings me neatly on to this. I'm going to be uncontroversial for a minute. The system of reparations and victim participation at the International Criminal Court requires root and branch overhaul. It is expensive, ineffective, distorts and prolongs the trial process, and delivers too little, too late to the wrong people. At the sub-articles there, you'll see the proposals I would make. Obviously, this requires amendment to the statute, the rules, and the jurisprudence of the court to date. But experiences in the Bemba case, particularly where we stand now, dictate that this must happen. The first thing that should happen is that reparations should be untethered from the conviction of an accused. This would reduce the amount of delay in the effective delivery of reparations to victims and negate the crushing disappointment that an acquittal brings. It would also reduce the pressure on the institution as a whole, the prosecution, representatives of victims, and trial chambers to deliver a conviction and free them up to do their job with clarity. The Trust Fund for Victims should start work on situations, not on cases that have been confirmed. Commenced early and untethered from the conviction of the accused, work on schemes for reparations could be begun early. Proper effect could then be given to the distinction in the rules between participating victims and those seeking reparations. Comforted that a scheme to repair the harm to their community was in train, victims might be more sanguine about whether they wish to have their views and concerns presented to a court in The Hague. This week, a breathtaking submission was made by the legal representative of victims in the Bemba case to the effect that she should be given more time to discover the victim's reaction to Mr. Bemba's acquittal. The underlying inference is that in 10 years, the possibility had never been addressed with them. That is not the only respect in which the ICC's dealing with victims has been a cruel service. The possibility of delivering individual reparations to each of those who had sought to participate in the proceedings was always remote, and especially in the amounts that they were encouraged to seek. The industry that was victim participation in the Bemba case has to be calmed. You simply cannot have intermediaries running round a war zone, handing out forms to people, telling them that we now have a rich man in custody and you're all going to get $1,000. That has to stop. It does no good. This institution cannot deliver that, least of all in somewhere like the Central African Republic, where nobody can go more than 5 miles from Bangui at the moment. The whole question of raising victims' expectations pre-trial needs to be addressed, and needs to be addressed seriously, because this is where we end up. We end up with people saying, well, what about the poor victims? Well, it's not Mr. Bemba's problem, with the greatest of respect. People have raised their expectations and now they're trying to quell them. Trial participation. I am frankly very disappointed that this appeals chamber didn't deal with the proper ambit of victim participation in the trial. The Bemba case certainly represented the high watermark of victims' trial participation. The legal representative of victims were afforded virtually unrestricted rights of cross-examination. This added months to the length of the trial and imbalanced the proceedings against the interests of the accused. The rules are clear enough, and it is the responsibility of all parties, including the prosecution and the chamber, to ensure they're upheld, to ensure that victim questioning and victim adduction of evidence is limited to that which is authorized in advance and is relevant to the personal interests of victims and expresses their views and concerns. One of the central aspects of the decision, and I'm moving rapidly from topic to topic here, was the inadequacy of the charging documents, the document containing the charges, and the fact that the conviction far exceeded the charges which Mr. Bemba faced. I'll deal with this very quickly. There's no point in moaning about this. Prosecution have to present an accused with a document which he can identify, in which he can identify the charges he faces, which he can properly investigate, and which he can defend himself against. Full stop. For what it's worth, I would support a system where amendment of the charges was possible without returning to the pre-trial chamber. That seems to me to be ridiculously fat, and that if you notify an accused that you're amending the charges in front of the trial chamber, for example, then that's probably good enough. But there's no point in carrying on with the sort of charge which Bemba faced. Let's be honest, I'll come on to it a little bit later, but you can't charge somebody with murder over a 5-month period, over a 620,000 square mile area, on the basis that you can produce only one murder or two murders. You really do have to specify them. If you go into the indictments at the ICCBA, Srebrenica, for example, or Krajnik or Karadzic, when these crimes were alleged, they were alleged and proven in every single municipality. So charging documents have to be far more precise. I've hinted at this earlier. The Bemba case had a curious history. Of course, originally he was charged jointly as a co-perpetrator with President Patasse, the president of the Central African Republic at the time. Patasse was never arrested and died in 2011, which left Bemba as the only potential accused in relation to what had happened between 2002 and 2003. In investigating the case originally, the prosecution chose to interview most of the commanding officers in the Central African Command, and they inevitably told them that there was a command post in Bangui at which operations were coordinated, that President Patasse provided logistics and intelligence for the defense of his regime, and they pointed in every material respect to a system of command in which Bemba's troops were brought into. They were resubordinated and fell under that command. Once the pre-trial chamber told the prosecution that there was no case to answer effectively for Bemba as a direct perpetrator, but they could try charging him as a commander, the case was altered dramatically. The prosecution, of course, jettisoned all the witnesses from the Central African Command structure who would have effectively disproved the command case against Bemba. And they were left trying to satisfy the trial chamber that he had effective control over one portion of a mixed unit defending Patasse's regime through the mouths of victims and associated hangers-on. I've never seen anything like it. In every command case I've ever been involved in, you call people from the command structure. You call people to say, this is how this army was organized. This is who was in command. This is who he answered to. These were the disciplinary proceedings that were available to him. There was nothing like that in the Bemba case. It literally amounted to victims telling the trial chamber that stray soldiers who they believed were members of the MLC had said, we were sent by Papa Bemba. And how any chamber could have concluded that that gave them sufficient evidence of effective control, knowledge on the part of the Supreme Commander, or a failure to take reasonable measures, I simply do not know. And a lot of that's got lost in the wash. The appeals chamber smelt the injustice in this case. They smelt the falsity of the charges. And the lesson to be learned for the OTP is if you're going to bring command cases, you need evidence from within the command chain. And you need an expert. They did actually call an expert. His name was General Opande. Read the trial judgment. I don't think you'll find one citation to a word he said, because he simply had no grasp of the case whatsoever. So it's all very well complaining about command cases being lost, But if you don't bring the evidence to prove that somebody had effective control and had knowledge of the offences, you are going to lose them. This is just a feeling, but I don't think had the majority of the appeals chamber turned their mind to whether this case had sufficient proof of the contextual elements of crimes against humanity, that they would have found that it did. It was an issue that, if in effect they raised with us, we did plead it, but they became very excited about it, both during subsequent requests to the parties to make submissions and during the oral arguments, and they plainly did not think they were crimes against humanity. I'll embarrass Kate Gibson here by referring to her conversation with her other infamous client, Dr. Karadich, who asked her what the crime base was in the Bemba case, and when she told him it was 1 murder, 20 rapes and 5 acts of pillage, he said, "That's a normal Saturday night out in Belgrade." That might have been a bit flippant, but I do wonder how many arrests for murder, rape and pillage, or theft as we'd call it, would be recorded in the police stations of London on a Saturday night. It certainly doesn't sound like a crime against humanity. It certainly doesn't sound like widespread criminal activity. This is a document we put before the appeals chamber in our submissions on crimes against humanity, and I hope you can see it. It shows the Central African Republic, all 620,000 square kilometres of it, and it shows when and where the prosecution had evidence of crimes being committed. And as you can probably see, they're in 2 very distinct locations. One around Bangui, all within about a 2-week period at the start of the conflict, and the other at Mongumba on the 5th of March. There was nothing in between. All there was to fill the temporal gap of 5 months and the geographical gap, and for what it's worth, every single one of those town names was listed in the judgment of the trial chamber as being a place in which crimes had occurred. Not a shred of direct evidence that anything had ever happened there. But that's what was relied upon. What was relied upon in support of that was newspaper reports, NGO reports, to show that these sporadic bursts of crime at the start of the conflict and at the end were representative of crimes committed over the whole country and over the whole 5-month period. Sadly, we've got no guidance on this, but I'm pretty sure that had they been pushed, the majority would have said, that's just not good enough. And the answer to that is, don't charge it. If you haven't got evidence of widespread crimes, don't charge it. Don't confirm it. Don't convict people of it. Anyway, I'm being shouted at to move on. A lot's been said about appellate review. Really, I've got to finish. And there I've got a very nice picture of a referee looking into the VAR machine at the World Cup this year. Sadly, he didn't disallow that Korean goal, Jens. They did score it, and then they scored another one. You didn't think you were going to get away without me mentioning that, did you? The law moves on. 8 years ago, in a game between England and Germany, Frank Lampard scored a perfectly legitimate goal. The ball was a foot over the line, And the referee could look up at the screens in the stadium and see that it was a goal, but he couldn't change his mind. He couldn't correct an injustice. I'm not sure whether the formulation of appellate review by the appeals chamber is in fact a departure, but the law doesn't go backwards. It goes forwards. It takes account of societal changes. It takes account of technological advances like VAR. Appeals chambers here don't have much to do. You know, they took 2 years to review the Bemba case. Are you really going to say they're not going to mine the evidence? The footnoting in the Bemba judgment was appalling. It was appalling. There were factual findings which cited to Judge Steiner saying, we're going to take a lunch break now. There were factual findings which were supported by evidence which showed the precise contrary of the proposition in the judgment. You cannot have the standard of appellate review being held up as a barrier to preventing a miscarriage of justice. And it was brave of them to go where they did. Whether it is a departure or not, I don't know. I don't think so, but if it is, then quite right to. Last but not least, the statement of the prosecutor on the 13th of June and the subsequent rebuke of the president a day later, in my opinion, represents a real low point for the ICC. They show an institution really turning in on itself, and it was unfortunate. The prosecutor's statement was factually incorrect. The appeals chamber did not uphold the findings that Mr. Bemba had knowledge of the crimes committed by his troops, and they did not uphold the finding that he had effective control over them. And Judge Chile did not sign off on a retrial. He said he thought about it, but ultimately he agreed that Mr. Bemba should be acquitted. It was also arguably in breach of the Code of Conduct for Prosecutors. I have no doubt that a domestic attorney general would have found himself in serious trouble if he or she had made such statements about the ultimate appellate court in their jurisdiction. The mild rebuke from Judge Chile was little more than, as one commentator put it, a slap on the wrist. The fact of the matter is that we all now have to be careful about what we say to the media before, during, and after court cases. The President has reminded us about that. But I guess we all knew that anyway. Those are a few of the things I think we got from the Bemba case. Thank you for listening to me.
Thank you very much, Peter. I've seen presidents of appeals chambers try to cut Peter Haynes off mid-flow, and I've seen the success that they had. So thank you for indulging me for letting him get to the end of his remarks. We're moving quickly then to Dr. Caroline Bozeman. And my love affair with Caroline started about 15 years ago when we were together part of the defence team of General Gracien Kabaligi, the G3 of the Forces Armées Rwandaises in Arusha. And since that case, the Bagasora case, she has gone on to be an absolute powerhouse in the ICL world. She has represented accused here at the ICC, at the ICTY, at the Special Court for Sierra Leone, before the MICT, and she's now practicing as a lawyer in the Netherlands, where she specialises in human rights and, of course, in criminal law. And we're very excited to have her speaking to us today on a topic she's almost uniquely qualified to address, being the challenges of investigations here at the ICC. I'm very happy to give the floor to Caroline.
Well, thank you very much, and thank you for giving me the opportunity to speak about the one subject I'm most excited about, and that is conducting the investigations. I was looking on my front to have someone to give me a kick when there's like 10, 15 minutes past, because this is another topic we can speak about for hours. So I really, really, really would like to try to be short. So I look at you as the president of the ICCBA to make sure that I stick to my time. Conducting investigations, in my view, is not only the most exciting part of the defense job, the most challenging job of the defense job, but also, in my view, the most important part of the defense job. It's where we find the evidence to challenge the prosecution case and to build up your own case. It's where you find material to cross-examine the witnesses against you. It is something that not all of us may be familiar with in our domestic jurisdictions. I am by now much more familiar with it, but from my domestic jurisdiction, it's not very common in the Dutch system, and I guess in most European systems, it's not very common for the defense to independently investigate their own case. Normally goes through an investigative judge, or not at all, like in France, where you have to ask your questions through the investigative judge, and you have no way of investigating as a defense team. So the challenges here in the ICC is, first of all, to get familiar with this whole idea, the whole notion of investigation. It sounds simple and straightforward, but in fact it's not, although a lot of it is common sense nonetheless. There are three important aspects to a very good and efficient investigation. And one is adequate resources. A second is to compose a good team with all the necessary skills, at least combined in one team. And the third is to really familiarize yourself with the case against the accused, for the accused, but also of the contextual elements of the situation that you're investigating. Try to understand the political nature of the conflict and get to all the different alternative theories of what actually occurred. There may not be one book that can help you. There's not one guideline. Often you arrive in a conflict zone and not much has been written about it. So the starting point is to look for open source material to familiarize yourself with all that has been written, all you agree with, and you may not agree with. And then you might actually set out your own analysis of what actually happened in the conflict. And from there, to actually get a really good picture, of course, the number one source is your client. He will have his theory, and you'll discuss it with him. And you lead him through it. And from there, you look at, of course, the prosecution case and all the parts that you are seeking to challenge. You might, in some parts, not contest the prosecution case, and that would actually involve a different defense strategy than if you do contest it. So it's important to set out from the outset what we're actually looking at, and do not forget, these cases are very, very large and voluminous, so we're talking about thousands and thousands of pages that you have to analyze and understand. So it's important from the outset to work on a sort of scheme, to put everything in order. You can make an investigative report setting out the defense strategy, the defense theory, and the analysis of the case for and against. The defense theory is a very important aspect of conducting proper investigations. And I actually thought this is very non-controversial, something that applies anywhere. But Recently I was involved in a training of Dutch prosecutors, and they were not so keen on having a theory of the case from the outset, which was rather surprising, but they felt too bound by it. They said, we want to be open to everything. And I respectfully disagree. Of course, you want to stay open, and the defense theory will change over time. It's a working product. So you're not bound by it, but it does give you a guidance to go through in an organized manner. Because if you don't start in an organized manner, you'll lose track very, very soon. As I said, the case is endless. And as you go along, disclosure material will come to you. It's not all coming at the same time. At the outset in the ICC, you have a very small team, unless it's not on legal aid. But provided you're on legal aid, you start before the confirmation hearing. A normal team is one counsel, one legal assistant, and one investigator. And that is not a lot of people for the amount of material that you have to understand and comment upon and decide what your strategy is and your way forward. So that's also when I say adequate resources, this is the continuing challenge. The ICCBA is trying hard to push as a general defense theme, but it's also for counsel, him or herself, to negotiate properly with the registrar. You get a starting budget, which is way inadequate for any investigation. An investigation is very expensive. And so then you have to constantly negotiate to get more. You have to explain why and build up a good request. It's also important that this is more on a sort of political level, important to make the Assembly of State Parties understand the importance of an adequate defense investigation. If you do not have the adequate resources and the time, then there can't be a fair trial, especially in this two-party system where the prosecutor has had years before you even come into action, and of course has way more resources and way more members in a team. Let none of that be of limitation. It's just something that you have to be aware of. So you need a strong team, small but a robust team. Also, flexibility is important when you go to the field. But particularly being robust is important. Nothing on the defense side comes for free. It is often the case that if you go to a conflict zone, you might not find that the NGOs are going to be very cooperative. The state, unless you are representing someone who is a government member, is likely to be hostile to you. So these are things that you should be aware of, and you have to plan around it. Some of it you can, these sort of challenges can be overcome to some extent, for instance, by engaging the registrar and ask for a note verbal, for instance, to get into the prison, if otherwise you won't get access. So these are things that you should really prepare in advance before you go on a mission. Before you go on a mission, you have to be already familiar with the case you're dealing with to be to be successful. So as a defense team, small as you are, you will be facing many challenges. Well, we know people have ended up in prison, so there isn't always the protection that you may want. Before even going to a conflict zone, it's important to be aware of all the security issues in place. And I have to say there that you can also be too restrained if you seek the advice of the United Nations. you get a no to everything that you want to do. And in my experience, it was better to actually get advice from people locally who really know the area better. But the United Nations is always afraid for responsibility issues. And I remember being in the Congo, I was more afraid of facing the ICC than facing militia, because they didn't like it when you were disrespecting their rules. But if you don't disrespect their rules, you're really restrained and too controlled. You have to go sometimes to areas that are not safe, but sometimes you've got to do it. Of course, you have to be careful because there's witnesses, sources that you also need to protect. And this is sometimes the challenge, especially, as a blondie coming to a little village in the DRC, it's really hard to be unnoticed. It is something that can be in your favor, but if it all has to be confidential, of course, you have to look for other solutions. You might send your local investigator, and you might interview someone elsewhere, or you try to find a discreet place, which you don't always have. So you have to really look at the circumstances. They're all different in different conflict areas, and then just have to plan from there. That's where the investigator comes in place, because he's arguably the most important person in your team. And in the ICC, you have two options. You can get an investigator from the list of professional international investigators, or you get a resource person. I believe, I'm not sure anyone ever got someone from the list of international investigators, not least because they're very expensive and because we have such a limited budget. So if you do go for the international investigator, then within 3 months you're out of money. But most importantly, you need someone locally who can open doors for you. And I'm not sure that the most experienced British police cop is in a better position to do so than someone from that area. I believe you need someone from that area for language purposes, but also to get access. It can be helpful because often in these conflicts there is an ethnic component. It can be helpful to have an investigator of a different ethnic group than your own client is, because then certain doors may open that they otherwise remain closed. The investigator needs to have the confidence of your client, of course, very much the confidence of you as counsel. As counsel, you are responsible for your team. So it is something really important to make sure that your entire team is aware of the rules of integrity and that they know what their professional obligations are in terms of confidentiality and also on treatment of witnesses and so on. This is where we can learn from the prosecution. In fact, we can learn in 2 areas. We know that in the first few cases in the ICC, well, in fact, it's probably still ongoing, but the ICC, the prosecutor was using a lot of intermediaries without having proper supervision, without being there to really, they didn't even know what they were doing. They were completely free to conduct their investigations without any guidance, without supervision or anything like. And the result of that was that they were producing false evidence. They're producing so-called child soldiers who were not in fact child soldiers. And this happened in Lubanga and it happened in Katanga. But also afterwards, we've seen it in Kenya and the other cases, I'm sure, I somehow think it hasn't been resolved. this is something we can learn from, because we also want to make sure that our investigator is properly supervised. So whilst it's important to have someone locally, it's also good to work as a team and to make sure that the work is really under your scrutiny. And the second point, because then I'm running out of time, where we can learn from the mistakes of the prosecutor is confirmation bias. And in fact, just heard Peter already touching upon it on the level of the appellate level. There is this reluctance to accept that you're wrong, and this is something, a kind of a human feature. So sometimes I like to accuse the prosecutor of confirmation bias, but it is something that is a real danger on the side of the defense as well. And what I mean by that is, if you're not careful, if you don't take a professional distance, both from your client and from the theory of the case, then you could also be blinded to one way of looking at the evidence, and then overlook all the other aspects that you have to be prepared for, also in cross-examination and so on. So my one advice is keep that distance. You want to hear certain things, but don't make the evidence, don't mold the evidence, but let the evidence define your theory of the case, and not the other way around. That is maybe the piece of advice, and I stop here for further questions afterwards. Thank you.
Thank you very much, Caroline. It's such sound advice that we should all keep in mind in the investigations on both sides in future cases before this court. We're going to move swiftly on to Dove Jacobs. Dove is an assistant professor of international law at Leiden University, but most relevantly for our purposes today, he is the legal assistant of the defence team of President Laurent Gbagbo here at the ICC. And in that context, we're very lucky to have stolen him today, because the Gbagbo team is currently in the throes of drafting their no case to answer motion, which is due on the 20th of July. So I'm not sure how much sleep is happening in the Gbagbo team. So we're very grateful for him to have given us some time to speak with us today. He's probably best known for running the blog, the formidable international criminal law blog, Spreading the Jam, which if you don't regularly read, you should. And I'm very excited to hear his take today on the evolution of the procedural framework of the ICC from the perspective of the defence. Thanks, Dove.
Okay, thank you, Kate. As you said, I'm not getting much sleep at the moment. To show you how exciting my life is right now, this is my break. This counts as my relaxing moment and break. So I'm going to make the best of it and talk for about half an hour. No, just kidding.
You got about 15 minutes.
Just before I start, I was just to react to Caroline's last point, because I read recently the various opinions and dissents and separate and concurring opinions in the Bemba case, and this quote from Osuji's separate opinion struck me, and it actually perfectly illustrates what you said at the investigation stage during the trial, because he says, "The finding of guilt or its sustainment on appeal, beyond reasonable doubt, must result from a view of the evidence that is naturally compelling, in the sense of pointing to guilt with unstrained confidence. It does not result from giving bloated significance to available evidence in ingenious ways, nor from an analysis of the evidence that suggests purposeful tropism in the light of the indictment. In these things, the mind can begin to see what is not there." And I'd copied that quote. I didn't quite know how I was going to use it, but I liked it and put it in my notes, and you actually gave me an opportunity, because we go from investigation to the actual trial, and without talking too publicly about my case, I think there is an element of this in my case. This idea of starting to see what isn't there because you're trying to be ingenious with poor evidence. But anyway, so that's not my introduction. So talking about procedure, I could talk for hours and hours, as everybody said, and rightly so, given that it covers everything. So I'm just going to make two general comments and just pick and choose a few examples, and then we can open for discussion. When I was a student, I hated procedure. I took as little courses on procedure as I could to pass my exams and to get my degrees. I found it dry and interesting, and I hated it. And then years later, especially since I became a practitioner, I realized my mistake. One, I find procedure extremely interesting intellectually, and because I'm a nerd, that's important. So I actually enjoy procedure. But more importantly, I realized this is the heart of the system. This is the backbone of the justice system. Prohibition of genocide is abstract. It's important. We have to claim it. But it's not because you announce that you're prohibiting genocide that you have a criminal justice system. You could just as easily announce that people who are suspected of committing genocide, you put them against a wall and you shoot them. You're still enforcing the prohibition of genocide. So when ICL is not the prohibitions, it's not the substantive prohibitions. What makes international criminal law is procedure. It's the heart of the system. And it feels weird saying this here, because usually when I say this to my students, they're learning something. Here, obviously, everybody knows this, but it's still, even among practitioners, sometimes this is lost in the conversation, how important procedure is. And my first comment is, there's really a philosophical discussion. This is where the academic side of me comes out, but I think it's important of what is procedure? What is the purpose of procedure? And obviously, I'm going to give my opinion here, but I think that there are two ways of seeing procedure: as a balance of interests in the daily work. So you hear this all the time. You're balancing the interests of victims, of the defense, of court management, trial management, funds. Not enough money to do whatever, or it's taking too much time, or you're balancing all of this. And as a judge, procedure helps you to balance all these things. That's one way of seeing things. The second way is to see that procedure is to make the trial fair, to make sure that the defense gets every opportunity to punch holes in the prosecution case. And a good friend of mine who works in prosecution, so I won't name them, was telling me recently that a case is only good if the defense has had every opportunity to punch holes in it. That's what the defense is for. And if you don't allow every opportunity, then you don't have a good case. And this is my view, obviously. This is how I teach procedure. It doesn't mean I ignore the other things, but for me, the yardstick of determination of procedure is how you protect rights of defense. And this may seem very abstract and theoretical, but it actually determines how you solve certain procedural problems on a daily basis at the court. And an example I take often with my students is language. You cannot expect an accused to have everything, every possible, given the funds and how much it costs, everything in their language, especially if it's not a working language of the court, like French or English. And I have this discussion with my students as well. Can an accused get a judge who speaks their language? Should the accused have a judge who understands their language, who speaks their language from a cultural perspective? And often my students say, well, if there's one available, he should be on the bench. That's what I get, very pragmatic discussion. And I say, but is it a question of principle or not? You can't say that this accused is lucky to have a French judge because there is one available, and this accused who speaks, I don't know, Russian, possibly in the future, or doesn't have a Russian-speaking judge on the bench. Now, if it's a question of principle, then they've got to find it. I'm not saying I'm arguing for that now. It's just an example of whether you take it as a balance, pragmatic balance, or a question of principle. Anyway, my second general point is I want to reflect on the famous common law, civil law discussion and procedure. And for me, this is a plague. I hate this debate. I studied both in the UK and in France. I know both systems. I've worked at the international court, but I know for me, the common law, civil law debate has kind of clouded the discussion on procedure in international tribunals for 15 years now. It made sense at the beginning of the ICTY, possibly. It doesn't make sense anymore. The reason why this debate keeps coming back is because we're reinventing, it's not reinventing the wheel, and that's really the good metaphor, is that because we're electing new judges every X number of years who have no experience of international criminal law, they're recreating the debate when they're elected and when they come here. Because the only thing they know is our domestic system. So when, over a period of 9 years, judges have moved on to accepting this sui generis nature of ICC procedure, new judges arrive and are back to, oh, in Italy we do this, in Poland we do this, or in the UK we do this, and we're back to square one. Because new judges think that I know better. And this is a real problem. It's not a question of civil law, common law. It's a question of having judges here who know criminal procedure of any place. And you can all look at the CVs of the judges at the court. I don't need to write you, do a drawing as you say in French. But some of the judges here are not qualified to do a domestic criminal case, and suddenly they're dealing with the most important international cases, which is a problem. This being said, I'm probably one of the only French people in The Hague who is not trying to introduce more civil law in the system. I know a lot of French lawyers who are writing memos, who are working with former judges of the court, writing memorandums and having meetings at Hôtel des Indes and other places to decide to make it more civil. I disagree completely. I like common law. I like a party-driven system. I find it fairer. It might be longer. I hear the arguments. But given the difficulties with the training and competence of judges, I want them to have less power possible, to put it simply. It's not ideal. It's a pragmatic position. So I want party-driven. And I like the common law system. I like the fact that the defense can investigate and make their own case and not rely on the prosecutor's abstract respect for Article 54 of the Rome Statute, that it has to investigate both incriminating and exonerating evidence. That doesn't happen. Intellectually, it's actually a torture to impose that on someone. You're a prosecutor. Your job is to find evidence against someone. If you find exonerating evidence and you disclose it to a party, that's fine, as an obligation. But to expect intellectually a prosecutor to investigate both sides, I think that's not convincing. So I like the common law. I won't support the ideas that judges should be given more power. I've seen recent proposals and documents which I find unconvincing, but I won't go into detail because I don't have much time. So just to pick and choose a few examples in the procedure in the past 20 years. One topic which people who know me expect me to discuss is Regulation 55. Now, someone here can talk about it far better than me, at least in one case, Katanga. So just for those who might not know, Regulation 55 is a regulation in the regulations of the court which allows the judges to recharacterize the facts at the end of the trial from how they were characterized at the confirmation of charges, essentially. This concretely allows to change the mode of liability, for example, which is essentially how it's been used. It was actually used in every case. In Lubanga, it was used in Bemba for a minor, not as large in other cases, to change the should have known to, that's right, know or should have known. It's been used in Katanga, obviously, during the deliberation phase. It was used in Kenyatta, used. It was proposed by the prosecutor, never actually, no decision on it because the charges were dropped. It's been used in Bagbo. So it's basically this small regulation in the regulations of the court has become this provision which has affected the procedure, and I've been planning to write about this. Obviously, I have no time. But it's actually changed the nature of what's going on at the court. In ways which go beyond the recharacterization of facts. It's been used, for example, to change the whole case law at the confirmation stage. The case law was you confirm a mode of liability and that's it. You can't be an accomplice and the main perpetrator at the same time. That was the early case law. And with the Taganda and Bagbo confirmation decisions, they switched with absolutely no explanation. They actually, in the Bagbo confirmation decision, they quote to Ruto to justify the change when Ruto said the exact opposite, that you cannot be a perpetrator and an accomplice. And the justification for this was, among others, Regulation 55. We're going to notify you now that there might be 6 modes of liability, because like that it's fair to you, because they won't use Regulation 55 against you later on. You can see the perverse reasoning here. Regulation 55 should not exist. The judges invent it. It's unfair, I think, in many cases. And then they use that unfairness to say, we're going to do another thing to avoid that unfairness we created. And, I just want to be clear. We're really being, I mean, some would say this is like Trump signing a decree saying we're not doing the internment, separation anymore. Thank you, but you created the problem. So the solution you're providing is just, anyway. So Regulation 55 is a major problem because it's affected the whole procedure. And I have, 3 minutes? Yeah. So 2 other, just a side point about Bemba is there's also the question of the nature of the confirmation of charges hearing, which came out of Bemba, which you didn't mention, but it's also something which is a red thread through the 20 years of the court, because chambers have disagreed, defense teams have disagreed. The confirmation of charges hearing is also what the defense makes of it. So, for example, in the Bagbo case, we spent a lot of time on it. And we actually made it a mini trial, to be clear. Other defense teams have chosen different strategies, so it didn't seem like a mini trial. So I don't have a clear-cut view on this debate, but I think it's going to be, to look to the future, is going to be an important moment how the Bemba, especially the different opinions, are taken into account for confirmation of charges. Because it's been a mess from the start. What is confirmed, how it is confirmed, you had this footnote in the Lubanga, I think, decision on what is material, what is it? The facts which are, I forget the expression now, sorry. But there's an actual footnote for such an important issue. What is material facts are facts underlying the charges. It's unclear what is confirmed, what is not confirmed, what can be changed, and this needs to be clarified. Another thing moving forward is the evaluation of evidence. It's another debate which is in Bemba, but which was in the Bemba-Bist judgment, and which you can see in the Bagbo case, where clearly, this is public, you have different approaches between the majority and Judge Anderson, who dissented, on whether you decide now on the admissibility of evidence or at the end of the trial. And again, this is, I clearly have an opinion on this, which is it should be done immediately, but it's going to affect, let's see how the Bemba judgment, which actually explicitly says that the Bemba-Bist judgment was wrong. Judge Asuji, the president of the court, says, I disagree completely, it makes no sense. So there's an interesting judicial dialogue, if you want to call it like that, going on this point. And the last point I wanted to make was victim participation, and Peter already mentioned that, but one of your bullet points was, let's make sure that the victims participate based on what the texts actually say. And they don't say much. But article, already it's not, what's happened de facto is that victims have become a second prosecutor. That's to put it simply. And their role of, the notion of interests and concerns has been interpreted in such a broad way that they can basically make legal motions. Now, I wasn't in Rome. And I always hear people, it's less and less the case, I hope it's not because they're dead, but it's less and less the case that in conferences people stand up and say, I was in Rome, this is what we meant, and I have to answer usually, but you didn't put it in the statute, so I don't care what you meant. But I can't imagine that people who wrote Article 68.3 thought this means that the victims will give their victim representative will write legal motions on every issue. That the interests and concerns of victims meant that the victims give their interpretation of Article 28 of the Rome Statute. Gives their interpretation on rules of admissibility. Gives their interpretation, I don't believe that, and if they did, then they were wrong. That's not what interests and concerns means to me. And this is what it's developed, that they can give their opinion on everything. And if you look at the case law, they've made this circular reasoning where they've decided that any outcome of a decision is in the interests and concerns of victims. You see how circular it is, because they say the outcome of a decision on provisional release is in the interest of victims, so they can make comments on it. It's completely circular. It means that they have an interest in the outcome of every procedure. And the problem is, I think OTP, and I think you mentioned that both defense and prosecution have an interest in this. It's very rare to say good things about the former administration of Luis Moreno Ocampo. But one thing I think they did right was immediately in the Lubanga case, they immediately put their foot down and said, victims are one, they have one role, OTP has another. And the initial decisions on victim participation, the prosecution appealed. And I think they were right to appeal. Today, that's not the case anymore. The prosecution it's very rare that the prosecution sides with the defense. I know they agree with us. In private, they might say it. I know the OTP agrees when we say this is not the LRV's role here. But they won't appeal anymore. They never say anything because we've moved to this, and I'll conclude on that, to this situation where, as you mentioned Fatou Bensouda's declaration, where she concludes saying, I'm speaking in the name of victims. This is where we are at now, where there's a complete confusion between the role of the OTP and victims. And I think that it's a problem, and moving forward, in the victim's interest as well, we should probably review the system on this. But I'll stop now. Thank you.
Thanks very much, Dove. It's always such a pleasure to hear you speak, and I think I speak for everyone in the room to say we're glad you spent your study break with us today. And moving on, last but not least, to Marie O'Leary. Marie is the person, when you get an outlandish order from a chamber on some obscure point of law that was due yesterday, you think, expletive, I better call Marie. She is part of this fantastic team at OPCD who have our backs, who answer calls from the defence day and night, and who do their work with passion and with an incredible ability to always be right. And Marie has her background in defending accused at the ICTY, and we're so grateful that she made the transition to come over here to work with us all at the ICC. She's going to be discussing with you some recent developments in the way forward generally here at the cases at the ICC.
I love that, and thank you for that, Kate. I can never live up to the intros, that's for sure. I also think that if Dove thought that was nerdy at all, you should all buckle up, because this is going to get very nerdy very fast. Because I've had the illustrious invitation of discussing, under the context of the 20th anniversary of the Rome Statute, reflections from the defense, recent developments in ICC cases, and some major challenges ahead. So I have 5 minutes, 4 minutes, something like that. I will do my best. But that is a wide bucket of things, so thank you for that, and thank you to ICCBA for inviting me to speak about this, because I have a lot of thoughts about this document here, these documents here, and I am carrying it. Here's where we begin the Nerd Fest. Feel free to get out your copies of the Rome Statute. I'm sure you all have them with you as we go through this here today. My copy in particular, when I had this topic, I wanted to look at because anyone who knows me and has discussed any of these questions with me will look and see that mine is very well earmarked, notes all over in here, and little flags for every single issue that's come up. And when I say every single issue, it's only a small portion because there's so much that has been done within the Rome Statute over the last 20 years, and even over the last year. I consider this, again, anyone who knows me in this tome here knows that I consider this choose your own adventure. If anyone remembers those books, had the pleasure of reading them, where you're reading through a chapter and at the end of it, it says, if you want to get on the spaceship with the aliens, go to page 89. If you want to fire your laser beams at the aliens, go to page 92. And there's multiple stories within that story. If you haven't read these books, I can only encourage you to do so, because it does make this much more fun, because this is choose your own adventure in jurisprudence. I want to take you through 4 buckets I've learned, global areas, and they dovetail with a lot of issues raised here today, and I don't disagree with, I don't think anything anybody said today. I will try not to duplicate issues because I know time is of the essence, but 4 main areas I wanted to bring up here. One of them is Articles 7 and 8, a lot of numbers in here, 30 to 40 numbers I'm going to throw out if we get through everything. Kidding. Articles 7 and 8, war crimes and crimes against humanity within the Rome Statute itself. The lesson I've learned there is not WYSIWYG. It is, if you ever watched the Transformers, more than meets the eye. Because there are actually multiple sub-provisions within it that we don't actually even know, maybe to this day, are in there. And we know that from at least 2 cases that have come before the court. One of them, if we're looking at Article 8, in war crimes, anyone following the Bosco and Ntaganda proceedings, and I realize I'm preaching to the choir here, a lot of people know and work on these cases. Article 8, war crimes, we had this discussion that is framed in the counts 6 and 9 jurisdictional question. And counts 6 and 9 are counts of rape and sexual slavery against child soldiers in the context of war crimes. And the defense of Bosco and Ntaganda said those are not jurisdictional issues before this court because it was within the same forces. So they're not protected persons within the meaning of the Geneva Conventions. However, the trial chamber did not agree with that, and the appeals chamber agreed with the trial chamber and said that contrary to the war crimes enumerated in 8.2a and c, the chapeau of 8.2b and e do not expressly provide that the victims of rape and sexual slavery as war crimes have to be protected persons within the Geneva Conventions, or persons taking no active part in hostilities pursuant to Common Article 3. They found that international humanitarian law does not contain a general rule that categorically excludes these members, and therefore they are jurisdictionally within the court. Of course, this requires in this adventure to go to Articles 22 and 23 to look at nullum crimen sine lege, nulla poena sine lege, and to determine whether or not it's against a broad interpretation of the elements of the crimes or their extension by analogy. And again, they found here that they're not prevented from imposing these additional elements. It's perfectly fine because it is in conformity with conventional and customary international humanitarian law. They said, in fact, there is, and I quote, never a justification to engage in sexual violence against any person, irrespective of whether or not this person may be liable to be targeted and killed under international humanitarian law. So through this jurisprudence, we've developed a distinction here. A person may be a protected person for the purposes of crimes of rape and sexual slavery, but not protected as far as they're a combatant and can be killed within war crimes. So that's something that maybe on its face was not evident in Article 7. And so I'm, of course, reminded then of Article 8. Article 7, when we're talking about crimes against humanity, and of course, the Ongwen case. If anyone goes back a few years and you look at the confirmation of charges, it was discussed whether or not forced marriage is a crime against humanity within the Rome Statute. Because if you look through, you know that there are at least 10 enumerated crimes against humanity. But this would fall under Article 7.1k, they said, other inhumane acts. So there's a large bucket there at the end that could contain other provisions. And this is especially true when you consider that G, sub G in there, has all of the subs of rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of that quality. Which means that this is actually under other inhumane acts. So we're adding even there on top of all of those that are contained under G. So with Article 7 and Article 8, the elements of the crime, you don't necessarily have them all there. The crimes that are actually charged here are not all within the statute on their face specifically spelled out. And the reason that's important is to go back to Peter's point about charges. What are the charges? And to go back to Caroline's point, when you have limited resources for investigations, what are you actually looking at as the crimes here? They have to be noticed, as Dov said, at the very beginning, and we need to sort out what those charges are going to be, especially when we're factoring in that Regulation 55 that things can be moving targets on the ones you do have. So that was one of the areas that came up that was the most marked probably in this statute. The second is Considerations of interim and early release of sentence both have set an incredibly high bar at the ICC, in my opinion. In particular, interim release here is really discussed very seldomly, only in a handful of cases. And we haven't actually seen it being effectuated rapidly ever, except, of course, then most recently for Mr. Bemba. On the Article 70 case, there was no reason to detain him, it was determined, because his acquittal in the main case and following after, looking at provision Article 60, para 2, they said that governs the request, and it makes it clear that they can seek release at any point of the proceedings. Because part of the argument there was that the prosecution was saying that it doesn't apply to him because he no longer retains a presumption of innocence. Therefore, he cannot ask for release under 60 para 2. But that's not what the chamber said. They said at any point in the proceedings, this may come up for a defendant. But the one who has litigated this the most, I think, has been Mr. Gbagbo, who has been in custody since 2011. And repeatedly, it has come through the hopper for the trial chamber, the appeals chamber, the trial chamber, the appeals chamber, as far as what it would take to have Mr. Gbagbo released on interim release, as he still retains his Article 66, back in the statute, presumption of innocence. There was a decision last summer, in particular through the appeals chamber, that found that the trial chamber did err in several factors as far as considerations they can make when considering if he should be detained. One of them in particular was about his age. The trial chamber had said that his age should factor actually in keeping him in custody, because the older you get, the more reason you have to abscond. But the appeals chamber said, no, actually the law is the opposite of that. The older you get actually goes more in favor of being released, because presumably you have less time. It should also consider, they said, the appeals chamber, the trial chamber said you should also consider that health factor and whether or not that is a changed circumstance, because that's what they're looking at here. And finally, and this is probably the most striking to me, was where the trial chamber had said that he hadn't admitted any guilt. And therefore, there's no reason that actually went towards not releasing him because he hadn't admitted any guilt. To which the appeals chamber said that would create a paradoxical situation, that you would have to admit guilt to achieve release. Therefore, it is in violation of his Article 66 presumption of innocence and his rights under Article 67. So it was remanded, of course, to the trial chamber where they resumed and looked through these factors, but again, the majority decided he would not have interim release. There are dissents on these, of course. Judge Tarfusser has dissented, saying in particular that the trial chamber had a failure to appreciate the exceptional nature of detention prior to judgment. They had failed to consider his long detention to date, since 2011. They had placed a burden on the defense to provide a detailed plan as to the obligation. So you're reversing the burden and making the defense show why he should be released, how he can be released safely. There have been subsequent petitions in this. It has gone through again. We're still cycling through this, so it remains to be seen what will happen with that law. But that also inspired me to look back to Article 110, which is the revision of release, or the revision of sentence, provision. And Mr. Lubanga's case, because he's gone through 2 cycles of looking at his sentence and whether he had the ability to be released early under this provision. Well, Article 110(4)(c) takes you to the rules of procedure and evidence. And I think this is one of the things that struck me the most when you actually look at the rules that are there. And it's under, I believe, 223. I'm only on the Rome Statute, not the rules here. If you look through those provisions, they are quite distinct from what I had experienced in the ad hoc tribunals. Some of those provisions there in particular are things that the accused has no control over whatsoever, and makes it impossible for him to achieve an early release, or her to achieve early release, if some of these factors are in place that they cannot control. And in particular, there are 5 conditions there. You have that the conduct of the sentenced person while in detention shows a genuine disassociation from his or her crime. That one we can expect. That one is something that has been looked at ad hoc tribunals, I think. However, the prospect of resocialization and successful resettlement of the sentenced person might be factors outside of their control, especially if they no longer have resources or any sort of way to establish themselves in a community. Maybe they don't even have a community to go to anymore. Whether the early release of a sentenced person would give rise to significant social instability. That's something almost consistently the accused is going to have no control over, whether or not their release might cause instability in a region. Any significant action taken by the sentenced person for the benefit of the victims, as well as any impact on the victims and their families as a result of the early release. Again, I'm not sure from custody what an accused can do or what a convicted person can do to help the victims. They are quite limited because they are, in fact, detained. I also have a question about if they did try to do anything, how would that be perceived? It could be perceived in light of them trying to intimidate victims and witnesses. It may be perceived as them trying to have an ill effect on the community or that stabilization in that manner of reaching out. So it is something that has to be quite cautious. And then, of course, the individual circumstances, which everyone would be familiar with. But these are quite foreign to me, those middle three in particular, as far as if somebody can be released early or not. And a lot of it out of their control. His sentence is set to expire in 2020, so they've said they're not going to review it again on their own accord. If something does come up, there can be application. I'm going to move a little faster. Bucket number 3 here is Article 70, and simply on that I have, it is not contempt, and it is an incredibly complex provision. This is not a small case. Every time I hear that Article 70, Bemba et al. In particular, is a small case, I want to throw up my arms and scream, because it is not a small case in any way, shape, or form. Put aside the complexity of the evidence there, put aside the fact that it is the first mega trial as far as 5 co-defendants at once. You have so many things that are within that trial that have made Article 70 far more complex than any one that comes in the future. Any sort of contempt case would have been at the ad hoc tribunals. In particular, a very early lesson learned there was that Article 70 does actually rope back through Article 25 modes of liability. That means that you can have co-perpetratorship of interfering with a trial. You can aid and abet interference with a trial. And so we've had to cut our teeth on some of these modes of liability through this Article 70 case, which can be quite distinct from Article 5 crimes. That is something that has made this incredibly complex, in my opinion. There was an appeal decision on 8th of March. A lot happened on the 8th of March at this court here. And a lot of it that arises in my notes in the Rome Statute. There's a couple points buried, not that they're obscure, but within the very large appeals judgment that are significant, at least from a defense perspective, to me. The Article 48.4 immunities are discussed ad nauseum. And what they say is it means that the defense are immune from prosecution in the domestic cases, in domestic courts, from their work here, but not within this court. You're not immune from proceedings within this court for actions that could be taken there. Under Article 70B itself, the provision is only talking about documentary evidence when you're talking about presenting evidence. It's not presenting a witness, because that's a separate provision. It's only documentary evidence in that case. And importantly, it need not be a party. It can be the attorney proffering that evidence, the piece of evidence, but other people are imputed to this actual behavior. For example, in this case, Mr. Bemba and Jean-Jacques Mangenda, the case manager. But by saying it's not a party, it could be anyone. It could be anyone who's tendering evidence or associated again in this manner. So it's a pretty wide bucket there. Article 71C, the definition of a witness. As far as outlining those who can be corrupted, obstructed, or interfered with, they said it's far broader than 71A. In that context, it doesn't even have to be someone who's been interviewed by a party. It's anyone who has information or is expected to have information about the case can be interfered with for the provision of C there. And of course, Article 76, the sentencing, it brought out that you can't have a suspended sentence, which is interesting because you could, in certain cases at the ad hoc tribunals, you could suspend that sentence for those offenses against the administration of justice crimes. Here, they've determined we cannot do that. And that does have some practical and procedural ramifications, not the least of which is the resentencing hearings, which are ongoing right now. And my final note then, I think, at least the final area would have been reparations, which we've touched on here. I can't stress enough how much I haven't used the word untether, I've been using the word divorce. And I don't think there's a lot of disagreement. No matter if you're defense, prosecution, victims, most people want to see these things separated in some manner to make it a more meaningful procedure, as Peter outlined. There were 2 decisions on 8 March, one in Almaty and one in Katanga. And they're very striking, actually, the Katanga one in particular. The Almaty one, it simply went into the fact that the identities do not need to be disclosed to the defense if they're screened through the trust fund for victims. And part of that is that they're saying Mr. Almaty's interests at this stage of the proceedings are limited. In this sense, the trial chamber has already set Mr. Almaty's monetary liability, and, as argued by the legal representative for victims, the results of the screening process will have no impact on this. So we see where the proceedings and reparations involve the defense, but do not necessarily involve the defendant. He's a bit removed from this in that they say there's no use to give him these identities because they've already determined how much money he's to pay into this. We go on to the Katanga case where there's this large discussion about whether it is remedial or is it punitive. And this is a very interesting passage I would like to point you to look at in this 8 March decision from Katanga about whether or not it's punitive to the defendant. Because they're arguing in this case, the defense is arguing about joint and several liability as far as the multiple actors in these cases, but also the amount that then the defendant himself is assigned. And what we have is the defense saying it's not punitive, and the appeals chamber agrees, but says, quote, as long as a convicted person is held liable for the costs that it takes to repair the harm caused, there is no punitive element. That this amount may be high is simply a result of the extent of harm caused by the crimes for which the person was convicted. But if we're talking about the context of widespread systematic crimes, we're talking about large swaths of crimes, the amounts are going to be astronomical most of the time. And to have one person in the dock who then has to afford all of it, it's always going to be punitive, in my opinion. $1 million over my head, I would consider punitive. I think most of us would. So the divorcing the defendant from that in saying we have to put these people back to this harm, to repair this harm, it's understandable. But there does, I think, need to be a little bit more of an acknowledgement that it is punitive to that particular person because we're dealing with individual criminal responsibility. I am not going to get into the transgenerational harm issue, but that is also one to think about there. Challenges ahead for the defense, there are so many. I have innumerable numbers here of articles that we could actually go through, that there are so many challenges on the horizon, not the least of which is defending the crime of aggression when that comes forth, and how that will work in play. Article 66, Presumption of Innocence, and those rights of fair trial under 67 continue to be things that are fought, in particular, right of translation. In Gbagbo, the mid-trial brief, they recently determined it does not need to be translated for the accused because it does not contain the charges in a way that he needs to have it in a language he understands. Early charging documents as well. Looking at those translation issues, that's one of the ones that comes up the most, and also that what are the charges themselves? Those are some of the Article 67 things that are on the horizon, as always. Again, I have a note, territorial jurisdiction, all sorts of things in here, and affirmative defenses, which are being litigated right now in the ongoing case, are things to be watching for because those will affect everyone. I just want to end on one point of this. Article 123 is important because that's what allows us to actually call for review of the Rome Statute. It is amendable. They did amend it for the crime of aggression. There are calls to include further amendments under Article 8, including biological weapons and laser weapons and all sorts of other weapons that they would like, new weapons they would like to include in those provisions. So there is possibility to do that. It does require a large effort by the states, but it is something that if there's enough to fix there, and I think there's enough to at least look at this time, is something that we should perhaps be advocating for. With that, thank you.
What did I tell you? She's a gem, an absolute mega nerd. We're so happy to have her in our camp and on our side. We are already over the time we've been allocated for this panel, and I learnt today that I'm a terrible moderator. Given that my one role is to keep everyone in time, I've failed terribly at that task. But we have to stop soon for all sorts of technological reasons that are beyond me. But maybe if we could just take a very small number of short questions, and if the panellists could undertake to give very short answers, we could have a bit of interaction before we all break for lunch. So Dom is roving with a microphone. Is there anyone who'd like to put a question to our panel? And we see Kareem Khan, the president of the ICCBA, who's going to put a question to...
No, it wasn't a question, but before we ran out of time, I wanted to thank the panellists enormously. Kate, as always, has moderated fantastically, but also in addition, she's very humble, along with Chris Gosnell as co-chairs of the training committee for putting this together. That's the first point. And the second, extremely pleased that for once we have gender equality. We have three brilliant, I won't call them blondies, the way Dr. Bozeman called them, but three brilliant lawyers who are stars of the bar. So thank you very much for all of them, and also for the Bemba team and Bagbo for really fighting in the best traditions of the bar in both cases. These are marathon cases. The pressures on counsel, as Peter and all of our counsel will know, are immense. And I think the fortitude and the stamina displayed is something all of us are very for the contributions today.
Thank you. Thank you very much, Kareem. It's appreciated. Does anyone else have a question for the panel? I'm going to pass the floor back to Dove for another comment.
Just to pick up on this debate about divorcing reparations from the criminal liability, but then I think we need to open this kind of worms, this taboo. Why should it be at the ICC at all? I mean, I agree. I think that the NGOs shot themselves in the foot with victims' reparations by insisting that it be included in the Rome Statute, because now when they go to states for more mechanisms, they're told go to the ICC. So any proposal like Bessiuni's proposal years ago to have an international commission of reparations is dead in the water, because states will say, yeah, but it's the ICC. So when you see the budgetary problems of the court, that they have to beg, and this applies to everyone, it's not just a defense perspective, but that at some point last year, and this is on the public record because our presiding judge said it in court, we could not hold 3 trials at the same time because there weren't enough court officers, court ushers. So they had to, there were negotiations between the 3 trial chambers to know who was going to be in court. But then when I see every year at the ASP, great press conferences, and Japan is proud to announce that it gave 3 million euros to the Trust Fund for Victims, I'm sorry, I think there's a problem of priorities here. This is a criminal court. If it cannot satisfy its core function of prosecuting fairly, with enough court officers, with enough interpreters, with enough basic functions of a court, then I think that Japan is beside the point, and Canada and all those states who are giving millions to the Trust Fund for Victims. Again, this is not saying that reparations are not necessary. Please, I know, unfortunately, one always has to make this caveat. I'm not saying that there isn't suffering, crimes, but this is a criminal court, and it's trying to do everything and doing nothing correctly now. And this is a problem. So if you're right, then this should all be pushed out of the ICC in order to be more efficient, and for the ICC to use its budget to actually do criminal trials correctly.
And I imagine to respond to that, I see Jens Dickman with the microphone.
Yes, thank you very much. Thank you very much for raising victims' issue here on the defense panel. Most grateful for this. And I just want to echo your comments. And as you know, this conference and training on victims' issue here, organized by Oxford University and the ICCBA. And in fact, it really echoes your comments. And I think there is a broad feeling that something has to be changed, also from the victim side. Perhaps we are the victims are the second prosecutor, or are regarded in this way, but the very deep feeling is that there is a discrepancy what seems to be offered by Article 68 and especially 75, and then the reality. So I think this is one of the tasks for the next years. Amendments are possible, and it will be a long run. But I think it should be on everyone's agenda to push forward a discussion on a review on the victims' representation and participation system here. And it was very, very interesting and inspiring during this expert conference to see that there is research on its way. There's long-term 5 years project research to see how victims are seeing what's happening here. Is it really satisfying what is in the Rome Statute? Is the narrative correct, or should it be changed? And so this is something we should follow on, and again, I'm most grateful for highlighting this here on this panel. Thank you.
Any last comments or questions before we break? Coming back to Kareem.
Just on that last point, I think it was really a profound comment in relation to the impetus or the tension that is created, or the pressure that's created on judges to convict, or to make sure there's a confirmation in order to be able later on to give some kind of reparations. And I think the point that Dove has touched upon, and also Jens has touched upon, it's also been written about, as everybody knows, by even senior judges like Christine van Wijngaard, and the call for expanding the role for the trust fund of victim, and moving out really the responsibility of the judges, and allowing them exactly, as Peter has said, to focus on the core issues of trial management and the ultimate questions of determination of whether or not the charges or the counts have been established beyond reasonable doubt. So I think it's very productive that our colleagues who are responsible for victim representation are open for that debate and that dialogue. And I think that can be done in a very cooperative manner, because we all want, ultimately, the system to work better. It needn't be confrontational. It can be very constructive discussion, because ultimately it will be for the benefit of all.
I think that's a really good note to end today on. If I do say so myself, I thought this was a fantastic panel. I was glued to you all. If I can urge you, there's a Francophone panel happening this afternoon at 2 p.m. With a similarly wonderful cast of characters. Ian Edwards is going to be moderating. He's going to do a much better job than I did, but I'd just like to thank you all for coming here today and being part of this dialogue and of this discussion. So thank you very much.